attending here in person and also to those who are attending online. For those who don't know me, I'm Richard Sarl. I'm one of the barristers at Seven Kings Bench Walk, and it's my pleasure to welcome you to this seminar of the London Shipping Law Centre on the theme of self-help remedies. We're following closely on the heels of last week's talk on the Great Amanda. Had also very good attendance, and many of you will have been seeing people attend, speakers attend from both sides of that case. And one of the great features of London Shipping Law Centre is it brings together very experienced practitioners from different institutions. And on that note, I'm very pleased that whilst it's a 7KBW sponsored event this evening, we're able to have with us Thor, Maalouf and Mark Jones. We're very grateful to you both for taking part. I'll pass over to our chair in just a moment, who needs no real introduction. I'm sure Sir Julian Flaux will be very familiar to you. He's had a very long and distinguished career at the bar and on the bench. He's currently the Chancellor of the High Court, but he'll be retiring from that post at the end of the month and coming back to Seven Kings Bench Walk as an arbitrator. So on that note, I'm going to pass over to Sir Julian to introduce Stephen Kenny.
That is liens on subfreights, which I must confess I hadn't actually encountered, I don't think, since I was at the bar. So I'm looking forward very much to hearing what our speakers have to say on the subject. And I'm sure that I'll learn something, and hopefully you all will as well. Our first speaker is Stephen Kenny, KC, who again probably needs no introduction. Stephen is one of the leading practitioners in the marine shipping and marine insurance field. He's specialised in, particularly in scuttling cases, which is where I encountered him most recently. He reminds me in the Brillanto Virtuoso. And he's also been involved, along with, I think, most people in Seven Kings Bench Walk, in the aviation insurance litigation, which is ongoing. Stephen has one black mark against his name, which is that he was my pupil a long time ago, but we'll try and forget that. Stephen, we're very much looking forward to hearing you speak.
Thank you. Thank you, Julian. Yes, I was Julian's pupil, and he, of course, taught me everything he knew.
Which is nothing.
And I've gone from there. Right, evening all. This evening we're going to be talking about forms of security, liens and the like, that a ship owner, registered or disponent, has to ensure payment to him of sums due from a charterer under a charter party. And you may start by thinking, why are we being so one-sided? Why aren't we thinking also about the rights and powers that a charterer has to recover sums due from an owner under a charter party? The short answer to that question is we don't have time. But to make a rather obvious point, a charterer, if he needs a remedy against the owner from whom he's chartered the ship, has a rather obvious way to secure his claims. He can arrest the chartered ship, or indeed a sister ship, for any claim for default in performance of the charter party by the owner. And ships are highly visible. You can chase the asset around the world to arrest it for security. And at least in English law, once the charterer has issued his in rem proceedings, his right to arrest and his claim is not defeated by a subsequent change in ownership. So that's a useful thing for a charterer. Owners need a bit more help because the assets of a charterer are elusive, transient, and mutable. So what we're looking at is ways in which an owner can grab assets of a charterer to the extent they're identifiable in any form at a particular time before they go effectively into the internet banking system and are lost forever. I'm going to address a special form of security available to an owner or disponent owner generally under a time charter, and that is the lien against subfreights. You will occasionally find the same device in a voyage charter. The last extract in your handout refers to the GenCon Charter Party 1994 form, clause 8. And you will see in that there is a lien on subfreights given to the owner under a voyage charter. For simplicity's sake, I'm going to ignore that. There's no cases that address that situation, but by the end of the time I've finished speaking, you may be able to work out how it might operate. And then Thor is going to address the owner's power to intercept or divert bill of lading freight. And Mark Jones is going to address the surprisingly difficult subject of the owner's lien on cargo. So let's get going on the lien on subfreights. And I'm going to refer to our owner. You can think of him, if you like, as our client. He's time chartered his ship, either for a trip or for a period. And when I say owner, I don't, of course, mean just a registered owner. He may be a disponent owner, someone who has contractual control of the ship under a time charter or a demise charter, or he may indeed be the final legal and registered owner. Anyway, he has control of the ship. Whoever he is, we assume he then cedes that power to employ the ship and to direct her on her courses to a time charterer from him in return for the payment of hire. That's the chartering arrangement we are going to be interested in. And for simplicity's sake, I'm going to refer to that as the head charter party. Now, I'm going to press this and hope that something happens. This is my first slide. Now, usually a time chartering owner will have what is called a contractual lien on subfreights. And you can see in front of you the original NYPE form, clause 18. And the bit that I have quoted is the bit that I am interested in. A lien upon all subfreights for any amounts due under this charter, including general average. And then there are similar clauses. I'm not going to read them all. You can see them in your handout and you can see them on the screen. There is a similar clause in the bull-time charter form, clause 17. And then I've also quoted for you clause 26 of the shell time. And just make sure I know where we're going in these slides. These are all contractual liens on subfreights, commonplace in time charters of all descriptions. And what you may ask is a contractual lien on subfreights. It is not a normal possessory lien at all. You'll know that a possessory lien is the right to retain and refuse to give up some tangible thing in the possession of, well, in this case, the ship owner, until due payment has been made to him. But of course, the point about subfreights is that they're not in the possession of the ship owner at all. And indeed, they're not tangible things. So possession is a difficult concept. What we're talking about here is the charterer's own rights in respect of freight earnings that he, the charterer, may make from his chartered employment of the ship. And what the agreement in these clauses achieves, the charterer thereby confers on the owner a lien on his, the charterer's, subfreights. And it gives, as I will describe it, a rather limited and contingent right, interest over and in respect of the charterer's future freight earnings from the ship. When I say future, viewed from the time of the charter party of the contract. So the lien on subfreights is not really a lien at all, and it turns out to be something very much more complicated, and its legal character has taken a good deal of working out in the authorities over the course of more than a century. I'm afraid there is simply no time to take you through the entire history, for which you will be grateful. Let me therefore summarize where we have got to, and my summary is based on the latest case in a very long series, the Western Moscow, a decision of Mr. Justice Christopher Clark. But interestingly, exactly the same analysis was adopted in Singapore in Diablo Fortune against Duncan, a 2018 case. And even more interestingly, the Singaporeans got to exactly the same result without even referring to or being referred to the Western Moscow. So two courts have come to the same conclusion. That's good enough for me, and I hope it's good enough for you. So we go to the next slide. Let's see if I go in the right direction. How does it work? Firstly, the relevant language of, let's take clause 18, for example, expresses, it has to be said not very obviously, an agreement to transfer, that is to say, assign to the owner the charterer's future rights to receive subfreights earned by his employment of the ship. So that is an agreement to assign rights that are not yet in existence, because the charterer at the time of contracting hasn't even started employing the ship and therefore has no rights to any earnings. It's an agreement to assign future rights. And those of you who are sufficiently well steeped in equity will know that such an agreement has an established effect, tail being the official receiver. When those rights to earnings do eventually come into existence, when the charterer does for some time become entitled to some freight under a subcharter or under a charterer's bill of lading, then that right to freight is automatically and immediately assigned in equity to the owner. It becomes the owner's as soon as it comes into existence. But that's just the beginning. The lien agreement in the clause, the agreement to assign future rights, provides merely a security interest, as the word lien suggests. And it is a security interest for any amounts due under this charter. That means the head charter, of course. Unless and until there are amounts due under the head charter, the lien, the security interest, has absolutely nothing to do. If everything continues smoothly under the head charter, hire is paid on time, sums are paid under the charterer's account on time, the lien has nothing to attach to. And so long as the charterer is behaving nicely, he is entitled to deal with his subfreights exactly as he wishes. So the lien only operates when there is an amount due under this charter. How does that work with property? Because we have to imagine that all these rights as they come into existence are now the owner's. They've all been assigned to the owner. The way it has been rationalized, has to be described as a rationalization, is that it works in the same way as a floating charge, such as a charge on book debts from time to time. The right to exercise security over the freights owed to a charterer floats and doesn't attach until such time as, first of all, there is an amount due to the owner under the head charter, and the owner chooses to crystallize the floating charge by giving notice. So that's the way to think about it. It's floating security. It's floating security until exercised. I'll just go to the next slide. You have to give notice. And notice of the exercise of the lien given to whoever owes the charterer the freight. Don't serve notice on the charterer. He knows he's in default. You serve it on the person who owes freight to the charterer. Notice of the exercise of the lien operates as notice of the assignment of that freight to the owner and perfects the assignment. And I should add that notice can be given equally to an appropriate agent, such as the subcharterers managers, the shipper, for example, shipper's agents at the port of loading of goods under a charterer's bill. Now, if the notice of the exercise of the lien reaches the subcharterer target before the subfreights have been paid, then, as I say, notice of the assignment perfects the assignment, and all future and unpaid subfreights become the owner's absolute property and must be paid directly to the owner, missing out the charterer, therefore, until whatever amounts are due under the head charter have been satisfied. If the subcharterer ignores the notice and pays the freight it owes to the charterer, then that does not discharge the debt, and the subcharterer or shipper, under the charterer's bill, remain liable to the owner. And that is simply the ordinary effect of a debtor ignoring a notice of assignment. If you pay the wrong person, you have to pay again. We're talking about a floating charge that crystallizes on notice, but can only be exercised when there is an amount due under the head charter. Symbols. Next one. What is secured? What is meant by amounts due under this charter party? And that does mean the head charter. Now, in the NYP form, general average contribution is expressly mentioned, so that is an amount due under the charter party. What is plainly included in amounts due under this charter party is all liquidated sums falling due to the owners under the terms of the head charter. And it goes a little further than you might expect. It's now long established that the expression extends to all sums due to the owners under what might be called the charter party account. So that includes disbursements made by the owners for and on behalf of the charterers. We have it on ancient authority, which I think I have given you. Yes, Samuel and West Hartlepool, recently followed in another Singapore case. If the owners have paid for bunkers, which the charterers should have paid for, or which the owners can claim in the charter party account, that is included. That is a sum due under this charter party. Does it include unliquidated damages for breach of charter? I think that's much more doubtful. I don't think that's an amount due under the charter party. It's a claim for damages for breach of the charter party. But if you look in your exciting little handout, look at the Bull-Time form, clause 18. It says this lien secures all claims under this charter. So perhaps that goes a little bit further. No one knows yet? Plenty to argue about. My next slide. Now, what are subfreights? There has been a long argument about whether when a clause of this kind refers to subfreights, does that include subhires? So sums due under a sub-time charter to your head charterer. Conflicting decisions have been given. I'll run you through it very quickly. Mr. Justice Lloyd said it does include subhires in a case called the Cebu. Mr. Justice Steyn later in related litigation said no, it doesn't. When they may say subfreights, they mean subfreights and not subhires. For what it's worth, I always preferred the earlier decision, the Lloyd decision, but in the bulk Chile at first instance, Mr. Justice Andrew Smith discovered a rule of precedent that where there are two conflicting decisions at first instance, and the later of the two has considered the first in reaching its decision, it is the later decision that should be followed unless there are cogent and convincing reasons for not following the later decision. So in effect, the bulk Chile has determined the matter. Subfreights does not include subhires. even though actually, looking at Mr. Justice Andrew Smith's decision, he rather hinted that he preferred the former view. Nonetheless, rules of precedent. That's the state of the authorities on this point, but the market has taken its own view. And if you look in your handout at the 1993 version of the New York Produce Exchange form, you will see that the words and or sub-hire have been added. And in other forms, you very commonly see brokers adding in and sub-hires after the words sub-freights. So that appears to be what the market prefers, and I think you can infer thought it had always meant. Anyway, for you, the important thing is to check the clause, see what it actually says. Giving of notice to the person owing the sub-freight to the charterer involves no formality. You can send a text if you like. But I don't suppose that giving notice of a lien on sub-freights or sub-hires is self-explanatory. So to make it comprehensible, my suggestion is that the notice should explain that the relevant earnings have been assigned to the owner, and the effect of the notice is to give notice of the assignment, and that therefore all sums must be paid to the owner for the time being. Recipients of that sort of notice may not like it, but I think they would understand it. Certainly their lawyers would. A few things just coming out of all this. The lien on sub-freights and presumably sub-hires attaches to those earnings as such. If the sub-charterer has paid his freight or his sub-hire to the charterer before he receives notice of the exercise of the lien, the paid amount has simply ceased to be an earning, a sub-freight or sub-hire. There is nothing for the charge to crystallize on. And paid in that context means paid to whoever the charterer has nominated to receive his freight. So if it goes to an agent or a bank, that's the end of that. You've missed it as an owner. It's gone. It's been paid. What about sub-freights and sub-hires? You can add as many subs as you like. Here things get legally really very exciting, and I can see the pulse quickening in all of you. Can the head owner exercise his lien on sub-freights down a chain of sub-charters to intercept, if at all possible, and claim as his own hire or freight paid under a sub-charter? And the answer is yes. Decided in both the Cebu, the first one, and the Western Moscow. But Mr. Justice Lloyd also pointed out that that doesn't work in the bull-time form, because that lien only gives a lien on sub-freights belonging to the time charterers, and that must mean the head charterers and any bill of lading freight. That seems right, although there could be something to argue about there. If the chain of agreements breaks, then you cannot reach any further down. So what you need is a chain of lien on sub-freight, sub-hires clauses in all the charters down the chain. If that breaks, you can't reach down beyond the break in the chain. And this one takes a little bit more thinking about. The lien probably only attaches to the smallest amount falling due between all the charters along the chain. It's a bit complicated to work that one out, but the essential point is that each assignee can only have agreed to assign up the chain what has been assigned to him by his immediate assignor. So if it's thrupp and halfpenny between C and D, it doesn't get any bigger as you move up the chain. You cannot, or down the chain, you cannot go beyond that. What about the point that the lien can only be exercised when there is an amount due under the head charter? If there is a chain of subcharters, does that mean you have to establish that there is an amount due under each of those charters, subcharters, all the way down the line before you can exercise the lien? That appears to be the suggestion of the editors of time charters, So if there is a break in liability, if there's no liability somewhere in the chain, you can't go beyond it. I have to confess, not so sure that they're right about that. You ask yourself the question in company law, does a floating charge over book debts, when it crystallizes, when it's exercised, does that only attach on the book debts existing at the time of crystallization? What happens to book debts falling due the next day? I think that's probably caught by the exercise of the charge on book debts too. But I have no authority for it. Go figure. There might be something somewhere in the equity reports, but I've not been able to find it. And the lien can only be exercised, of course, by the owner if and for as long as he has sums outstanding under the head charter. Once he's recovered everything that is due to him, the lien has to be withdrawn, the charge refloats or decrystallizes, everything goes back to normal. And what if the owner has already somehow recovered more than was due to him in this exercise of liens? He has to account back. No one has decided to whom. It's either to the head charterer, or to those from whom he took subfreights, probably in proportion to their contribution to the surplus. Anyway, no direct authority, something to worry about there. And what if the subcharterer doesn't pay the owner because he's ignored the notice and he's paid the charterer instead? Well, as I say, you can sue. As the owner, you can sue. It was yours, your property. But how and where? And the answer to that is, I think, because you will be suing as an assignee, maybe a multiple assignee, of a right originating in the final subcharter or the sub-subcharter or sub-sub-subcharter against whom you are trying to recover your money, you are bound to enforce rights in accordance with the terms of the contract under which the assigned right ultimately originates. So it would be under the sub-sub-subcharter. And you have to do so in accordance with the terms of that contract. So if there's an arbitration clause in that contract, you must arbitrate accordingly. The authority for that is there on the screen, and the Arbitration Act, section 82(2), references in this part to a party to an arbitration agreement include any person claiming under or through a party to the agreement. So you have to exercise rights in the final contract in order to recover. So you have to start an arbitration in whatever the ultimate charter arrangement says. You may not know what it says. Take a punt, start an arbitration in London. You'll be right twice out of 3 times, but you can see that there are difficulties of information. And the final twist in our tale. Does this charge have to be registered? You will, of course, know that under section 859H of the Companies Act 2006, a charge created by a company is void against a liquidator, administrator, or creditor of an English company unless it is registered, and registered promptly. So, thinking of our chain of charter parties, you have to look along the chain and see whether any of them, any of the charterers, is an English company. And if it is, you then have to check whether or not that charterer has registered its lien, or the lien that it granted to its immediate owner, in the company's registry. Fat chance. That has never happened. And accordingly, so far as it relates to subfreights and subhires, the lien on subfreights will be ineffective and void, and I've given you the authorities there. Now, of course, in the modern world, English company time charterers are as rare as hen's teeth. They're almost unknown. But just before you all relax, what about Singapore? Singaporean time charterers are distinctly less rare, and the law in Singapore is effectively the same. Unregistered charges created by a Singaporean company are void against anyone we're interested in. And that is decided in the case which I referred to earlier, the Diablo Fortune case. It did suggest that this was unfortunate and there should be legislative reform in Singapore, but I'm not aware of any having taken place. And just for your note, and I can see you all taking copious notes, in Hong Kong, the position for some reason is completely different, and a lien on freights, sub-freights, does not have to be registered at all. So don't worry about Hong Kong time charterers, it's the Singaporean ones that matter. So what happens in an English arbitration involving a Singaporean charter or sub-charterer? Do the arbitrators have to apply this Singaporean company law? Now that raises a fascinating question in the conflicts of laws of more complexity than I have time to explore today. But if it comes up, please bear me in mind. I will consider your instructions carefully and provide a very cheap and reasonable advice. That's all I have to say. Thanks very much. I'm going to hand on back to Julian.
Thank you very much, Stephen. I meant to say at the beginning that I think the sensible course is to take any questions at the end rather than to go along. So we'll turn now to Thor Maalouf, who's a partner at Reed Smith in the Shipping and Transportation Group. She is going to speak to us about redirection bill of lading freight.
Thank you very much. Thank you, everyone. And while I'm saying thank you to Stephen, who actually lent me the bullet points for my slides. Can I borrow the slides zapper? Yes, I'm Thor Maalouf, and I'm going to be talking about a different remedy, the redirection of freight under owners' bills of lading. And I think this is actually quite a simple kind of remedy, but one of the complicated things that I think I just need to explain first is that it really does arise under a contract of carriage as evidenced by a bill of lading and not under a charter party. And that's probably the first complicated thing about it, really. So it arises under owners' bills of lading. So well, we talked before about the text of a charter party and the fact that rights in respect of liens need to be reserved under a charter party. Let's put that to one side, because this remedy really comes out of the contract of carriage. Although we are going to talk a little bit about terms of charter parties and things that happen under charter parties that might affect this remedy, it arises under the contract of carriage. And it's a remedy that can be exercised by an owner under an owner's bill of lading. And an owner's bill of lading, by that I mean one that binds the owner of the ship as the carrier, because often we see bills of lading being issued by charterers or charterers' agents at their offices, when in fact what they're doing is issuing an owner's bill, one that binds the owner as carrier, for example, because it's been signed for or on behalf of the master, and therefore binds the owner as an owner's bill of lading. And this remedy, the right of redirection of bill of lading freight, arises under those kinds of bills, owner's bills. Now, you might say, Thor, what are you even talking about? What's bill of lading freight? Is this even a thing? And that's because when we bump into freight under bills of lading, we're used to the fact that the owner, as the issuer of the bill of lading, has already delegated away and nominated an agent to collect their freight. So what we normally see is freight being collected under a bill of under a charter party, a voyage charter. And if we think about what happens under the text of a bill of lading, it normally says on the face of the types of bills that we tend to bump into, freight payable as per charter party. So what actually has happened is the carrier, as the issue of bill of lading, has already nominated someone else to collect the freight. Whereas taking a step back, what we've actually got is a contract of carriage under which the carrier undertakes to carry the goods for the cargo interests, and the cargo interests are paying consideration for that in the form of freight. But typically when we bump into bills of lading, they're not paying the carrier, they're paying an agent who's been nominated to collect the freight on behalf of the carrier. And that can tend to be the disponent owner under a voyage charter. So if we want to exercise this remedy, we'll need to identify who might be the person who is due to pay the freight under this bill of lading. And often that will involve having a look at the bill of lading and figuring out what are its terms, which charter party has been incorporated into it, which charter party is meant when we say freight payable as per charter party, and have a think about who is meant to be and who is being nominated as the person paying the freight under this contract of carriage. The idea behind this remedy is that if I as a carrier have previously nominated an agent to collect the freight for me, I should be able to, with notice, change the identity of my agent who's collecting the freight. And by doing so, I could choose to nominate myself instead of the disponent owner, for example, under a voyage charter. And that way I could reach around potentially my own charterer to get at freight that is payable under a sub voyage charter or a sub voyage charter and get that paid to me. So in answer to the question, can I reach down to grab the freight from someone else? Yes, I can as the owner. And this right has been recognised in quite a long line of cases and authorities in English law, and the more recent one being the bulk chili case in 2013, which went to the Court of Appeal. And if you get the chance to read it, it's quite a helpful judgment at setting out what this remedy involves. In the bulk chili case, the head owner had time chartered the ship, and then there was another time charter beneath that, and then a voyage charter. And the head owner hadn't been paid hire that they were owed, and they wanted to try and seize some monies that were payable under the voyage charter. And in that case, they succeeded in redirecting payment of the freight payable under the voyage charter to themselves by redirecting that bill of lading freight. And the Court of Appeal sort of set out how this remedy works. They said that if you take a look at the bill of lading as a contract between the shipper on one side and the owner on the other, under which carrier's freight has to be paid to the carrier's nominated agent, then once it's clear that the person identified in the bill, which can be via the incorporated freight terms or via an incorporated voyage charter that's named in the bill of lading, they are merely the owner's nominated agent, if we construe the bill of lading, and that agency can be changed by notice. So the carrier can simply give notice to cargo interests who are liable to pay that bill of lading freight and say, disregard that agent that I had previously nominated and instead pay me or pay to my order someone else. That then begs the question, who do you need to give notice to, and when do you need to give notice? As Stephen mentioned in relation to liens, the notice has to be given before the monies have been paid. And if freight's already been paid in accordance with the contract of carriage's provisions, then unfortunately it's too late. The ship has proverbially sailed. But if that freight hasn't been paid, then you can give notice. who do you need to give the notice to? Well, it needs to be given to the person who's obliged to pay the freight under that original bill of lading evidencing the contract of carriage. So that can be the shipper, but it can equally be the holder of a bill of lading or the person who's due to pay the freight under the voyage charter that's been incorporated into that bill of lading. Who and when hasn't necessarily been limited to those traditional parties, though, and there is. Sorry, I wonder if I missed a slide. There is an old case called Multus Rederi that has suggested that it is possible to intercept that freight whilst it is in the hands of an intermediary agent between the person contractually responsible for paying the bill of lading freight before it gets to, for example, the disponent owner under a voyage charter. So when we look at the question of who, it may not just be those traditional parties, the shipper or the bill of lading holder. It is possible to grab this freight that you're seeking to redirect in the hands of an intermediary agency. And when it comes to the practicalities of exercising this remedy, if you imagine that you're the head owner and you're seeking to exercise this remedy quickly, it can be quite difficult to have at hand the identities of all these different parties. So just beware that the facts surrounding what you might need to know on the spot can be quite murky. And I'm sure I'm probably not the only practitioner who's sort of blatted a notice out in the hope that it will stick somewhere, that I've sent it to the right people. Okay, sorry, I think I might have got my slides in slightly the wrong order, but I want to ask the question, does the head charterer need to be in default? Because, got it, sorry everyone. You might think, as a head charterer, am I not just going to be really annoyed if the head owner exercises the right to basically reach around and grab the freight payable to me under a sub-voyage charter? Do I not need to have been at least in default under my time charter or my head charter? And the answer is no, you don't need to be in default. The Court of Appeal in Bulk Chile, when it was explaining how this remedy arises, it was very keen to explain that this is a remedy under the contract of carriage, which is an entirely separate contract to the charter party. So the question whether or not there's been a default under that separate charter party by a third party to my contract of carriage shouldn't be relevant. So they said, so for the time being, we don't have any requirement for there to be a default. However, there is an obligation in the cases to account. If you are the head owner, you've exercised this remedy, you've grabbed the freight under a bill of lading, and now you're sitting on a pile of cash, which is actually more than what you are owed under your head charter. There is an obligation to account, and that's dating back to some very old cases. So one from 1905, which is from the days when judgments were just like 10 lines long, and I can't tell you about what the case was about. It seems to have been a head owner that was owed money under their head charter and successfully grabbed some freight under a bill of lading. And the court said they were either obliged to account to the charterer or to the sub-charterer. The Bulk Chile Court of Appeal said the authorities haven't been particularly clear about who you're supposed to account to for any excess that you've collected. Probably it will be the head charterer, but we're not really sure. You might ask, what is the point of exercising this remedy then if you're not owed any money by your head charterer? Well, you might exercise this remedy if you have a concern that next week or next month your head charterer might come a cropper and bump into some difficulties and you want to protect yourself. Although you do have the obligation to account, perhaps you can do that a bit slowly. But what about Yes, what about your obligation, sorry, not to interfere with the time charter? I mean, as a time charterer, aren't you going to be really annoyed? In bulk Chile, as I mentioned before, the court said that you don't have any right to complain if no money is owed under the head charter. But in a more recent case, MV Smart, some time charterers did try to argue that there should be a consequence if a head owner tries to grab a bill of lading freight when there hasn't been any kind of default under the time charter. That was a case where a ship grounded, and it turned out that the vessel was at fault for the grounding, and the charterers weren't very happy that their head owners had grabbed some bill of lading freight and tried to say that that act was a breach of charter. Well, in that High Court case in 2022, the High Court found that there hadn't been a breach of an implied term that the charterers tried to argue, that there was an obligation not to revoke a time charterer's authority to collect a bill of lading freight. So the answer for now is that you can exercise this remedy regardless of whether there have been rights or wrongs committed under the head charter, but that is just a High Court case. So watch this space. Things might change. Sorry, very quickly, lastly, and I apologize for my slides being rather a bit an erratic order. Do we worry about whether bills of lading are marked freight prepaid or not? Well, if they have been falsely marked as freight prepaid, that won't help a shipper who has received a notice of redirection. But if someone is a receiver of a bill of lading and has relied on a stamp on it saying freight prepaid, they might also be able to rely on a estoppel or a defense. But if they know that freight prepaid has been falsely marked on that bill of lading, again, that's probably not going to be helpful in a defense to receiving a notice to pay freight by redirection from the owners. So in summary, this is a really powerful remedy. It's quite simple. Watch this space on the MV Smart as to whether there needs to be any breach of the head charter or not. And I have a feeling that we might be exercising these remedies in the coming months or year, just the way things are going. Just a little feeling. Thank you.
Thank you very much, Thor. Our final speaker is Mark Joe.
Thank you, Julian. Yes, so this is actually a lien, which is really a lien, as we'd all understand a lien to be. Now, what I'm going to do is going to do a whistle-stop tour. The lien over cargo has been around for a very long time. I dare say that it is nearly perfected as a remedy, and between the wordings of the clauses, which have grown ever more aggressive over the years in owners' favour, and the attitude of the courts, that the lien over cargo is about as effective nowadays as it's ever going to get. There we go, that's a recipe for disaster, having said something like that. Now I'm going to do, is very much a whistle-stop tour, because in light of what I've just said, there are bits and pieces here and there which perhaps remain up for debate about the cargo over lien, the lien over cargo, sorry. I'm going to focus solely on the fairly routine scenario of a bulk cargo, in respect of which numerous bills of lading have been issued over parcels of that bulk in the usual way. The ship arrived, the bills of lading make their way to the receivers. They're in Julian door Stover, so that we have receivers who are lawful holders of the bill of lading, that are consignees at the discharge port. And the owner is now approaching that discharge port and is owed all sorts of money of one sort or another. So what is he going to do? That's what we're going to look at. I'm not going to look into the relationship between the owner and the charter in respect of the liens, and particularly cessor clauses and what happens as between owner and charter if charter doesn't procure an effective lien and so on. In practice, one of the principal reasons why the owner might be short of money is because the charter isn't good for it. So the owner is now sitting on a valuable cargo thinking, I want my money, how am I going to get it? My only leverage in practice, and I think we'll find out in law, is this valuable cargo. Right, so as I say, it's going to be whistle stop because we're already quite tight on time. Right, so this is a possessory lien. It's a classic lien. So the most famous definition is probably that from the Wilson line case. Said a possessory lien is a claim by a person in possession of the property of another who has the right to keep possession until the owner pays the debt in respect of which the possessor is entitled to the lien. Effectively, I get to hold on to Thor's cargo even though Sir Julian is the one who owes me all the money. In the Miramar, at first instance, Mr. Justice Mustill, as he was, and I'm going to read this bit out because it is particularly apt to our scenario. If the lien clause is to be useful, it must be understood as creating rights against third parties. A clause in the Charter cannot do this directly, and it must therefore have been intended that the clause would operate by way of incorporation into bills of lading. Since the clause is of a type which most intimately concerns the interests of the consignee in the carriage and delivery of the cargo, even the most general form of incorporating words would in principle be sufficient to produce this result. It's urged on behalf of the receivers that it would be anonymous, you know the word I'm trying to say, to let in by the back door a liability which, as I have already held, is not created directly by incorporation of the demurrage provisions of the Charter. One of the other reasons the Miramar case is well known. Nor, they maintain, is it reasonable to impute to the parties an intention to impose on the consignee a liability which cannot be ascertained without reference to the terms of the Charter. I do not accept these submissions. It has been a feature of shipping practice for many years that the ship owner looks primarily to his lien in case of dispute. And no doubt has ever been raised about the acceptability of the situation where the lien is more extensive as against the consignees than their own direct personal liability. And it's that last bit, it's the detachment of the consignee's personal liability from the debt in which the lien, in respect of which the lien is exercised, that is particularly important. The two are entirely separate. Oop, going the wrong way. So how do we end up binding that consignee? So we can do that two ways. The owner can ensure there's an express stipulation for a lien in the bill of lading itself, or, as is more commonly done, by incorporating the terms of a charter in the bill of lading, which include a lien clause. So under English law, general words of incorporation will suffice, as Mr. Justice Mustill said. Indeed, even the most general vague words will do. In one 19th century case, the words deliver unto he or they paying freight and all other conditions as per charter suffice to bring in the lien. While on the topic of incorporation, lien clauses do not generally refer to a specific party. They tend to be put in a passive tense or simply refer to the sums that are secured by the lien. So the problems of verbal manipulation that can crop up in relation to incorporation, like trying to read receiver for charter and the like, don't usually arise. This is an area which invites consideration of the hoary old chestnut of which charter party is incorporated. this is a problem where the bill of lading refers to the incorporation of charter terms, and then in the box, unhelpfully, no one has identified which charter they mean. I'm still at a loss after doing this for 25 years, why those in the shipping industry haven't noticed that this causes problems. But no one's given me an adequate explanation so far, other than once rather cryptically being told it's nice to leave some uncertainty about these things. There are some rules of thumb where you have a chain of charter parties that we're probably all rather familiar with. So if the head's charter party, at least if it's a voyage charter party, that's preferred on the basis that that's the charter that the head owner, who's also the carrier under the bill of lading, is a party. I've never been entirely convinced by the logic of that. It seems to me that a sub-charter is going to be more closely related to the actual cargo carried and the shipment of that cargo. And indeed, the shipper or the charterer is likely to be the person who arranges issuing the bill and has shipped the cargo, obviously. And it is the consignee who then steps into that party's shoes when the bill is transferred. So I'm not entirely sure why the owner gets special treatment on the basis of a presumption when the consignee doesn't. But that's the rule of thumb. The other rule of thumb we have, I should be skipped. Oh no, the other one is where the head charter is a time charter and the sub charter is a voyage charter, which is a classic scenario. The courts tend to prefer to incorporate the sub voyage charter on the basis that that's presumed to be the intention of the parties, because a voyage charter is much more likely to have apt provisions to fit into a bill of lading than a time charter. Indeed, in the Namfrey, it was said that it was a learned judge. Let me just double check who it was. Yes, Mr. Justice Carr, as he then was, said that he struggled to envisage when a time charter would ever be incorporated in a bill of lading. As it's turned out, time charters are indeed sometimes incorporated in bills. For example, a trip time charter arguably poses less difficulties from the point of view of whether the terms are apt to govern carriage under a bill of lading than a long period time charter. And as an example, I think I've included it, the Vincent, where there was a chain of 2 time charters and the terms of the sub-charter, sub-time charter were held to be incorporated. In fact, the head charter in that case was particularly inapt for incorporation, as it was the time charter by which the vessel was entered into a pool of vessels. So there were a number of clauses that really had nothing to do with particular carriage, particular voyages of carriage. Now, the courts, they essentially hate, I'm sure the Chancellor will agree, hate hold contracts to be void for uncertainty. So instead, with greatest respect, they tend to resort to what might be seen as somewhat arbitrary and obscure process of doing their best to identify the right charter party, and then citing one or more cases in which other judges happen to go the same way in somewhat analogous situations. To be fair, they have to do their best. Now, some commentators say that uncertainty is regrettable, and I agree, but it's not the fault of the courts. It's a problem entirely created by the parties. Everyone knows that charter party chains are a routine part of shipping. So why, when they issue the bill, don't they make it clear which charter is to form the basis of the bill of lading's contract carriage? But hey ho. So the cargo over which the lien is exercisable. So the owner's lien extends to all the cargo carried under the charter per the charter party lien clause. So it's very potent. And that applies even if, as in our scenario, you have multiple bills of lading. So one consignee might be saying, oh, I'm facing you're exercising a lien over the whole cargo for an entire freight. I'm only here about this small parcel. I just want my small parcel. And the owner's entitled to sit there and go, nope, I'm liening the entire cargo under this charter party lien clause that is incorporated in each of these bills of lading. Skip over the other point there. So in respect of which sums can the owner exercise his lien? So perhaps unsurprisingly, the charter party lien clauses throw the net over the sums in respect of which the lien may be exercised very widely indeed. The time charter clauses in particular tend to simply refer to for any amounts due under this charter. For what I understand are historic reasons related to the cessor clause and so on, and the way that, no, I'm not going to go further into that, go down a rabbit hole, tend to be more specific. So they refer to the right of the lien in respect of freight, dead freight, demurrage, and damages for detention. Or in the more recent version of GenCon, which I'm not entirely sure has been fully taken up, but very widely, for freight, dead freight, demurrage, claims for damages, and for all other amounts due under this charter party, including the costs of recovering the same. Much, much wider. The extent of that net is no surprise. The owner wants as much protection as he can get. And again, I'll reiterate here the point made by Mr. Justice Mustill. The extent of the charter party lien in the bill of lading is not dependent at all on the owner's substantive rights against each of the cargo owners personally under the bill of lading. And that's what gives the lien its true power. It can be exercised to procure payment of all sums, or all sums of the specified sort, due under the relevant charter party, even though the consignee is not liable for them either at all, or is only liable to a certain degree under the bill of lading in respect of his parcel of cargo. The owner can demand from each individual bill of lading holder the entirety of the relevant debt before he releases that cargo to each bill of lading holder. So a couple of caveats. The first, there's a couple of caveats into what I've just said about the potency of the lien. And these are matters of incorporation that arise in relation to the voyage charter lien clauses. So if the incorporated voyage charter party lien, if the incorporated voyage charter party and the bill of lading contain express provisions about freight, then when you go through the process of incorporation, the bill of lading's own express provisions for freight will almost always be applied. So you won't incorporate the conflicting voyage charter freight provisions. Now then, when you then interpret the charter party lien clause simply referring to freight in that scenario, then it's been held that the only freight that is caught by the lien is the freight due under the bill of lading. Because when you look in that bill of lading, the incorporated lien for freight, it's not described as freight under the charter party, it's just freight. So when you construe the bill of lading, the freight, the relevant freight is the bill of lading freight and only the bill of lading freight. That's particularly obvious when you have a freight to be paid as per charter party provision. So if you have a lump sum of freight, that's fine, but that's not the scenario we're generally talking about here. Here we're talking about a bulk cargo where the freight's been determined by unit. So in the charter party, it simply says X per ton. Now there is an old case, which I think I put up there. Fry and Chartered Mercantile Bank, which held in that scenario, like the first scenario I mentioned, the owner's lien is restricted to the freight per unit in respect of the cargo carried under the particular bill of lading. That's all that is secured under that bill of lading. So there you've got a division of the value of the sums due distributed out between each bill of lading holder. Again, that boils down to what I was talking about before, I think, is the proper way to analyze this. This is a matter of interpretation of the provisions of freight in the bill of lading and the interpretation of the charter party lien as incorporated in the bill of lading when it simply refers to freight without anything more. So the second caveat, there's no lien for sums not payable at the time of discharge or when the lien is exercised. That's a well-known general rule. Historically, many voyage charters provided for the payment of freight only on delivery of the cargo or after discharge. That is useless for the owner because by the time he wants his money, the cargo has gone. He's already discharged it. By the time he's entitled to his money, the cargo has gone. So one way round that is a drafting solution, which in fact appears in the GenCon, the old GenCon form. The owner is entitled to call for payments on account of freight, and that ensures when that is then not paid, he can exercise the lien over the unpaid payment on account. There's no similar provision in respect of demurrage. And demurrage was a little bit different. Demurrage tends to accrue on a day-to-day basis. So the owner gets to keep on saying to the consignee, no, you're still not having your cargo, you're still not having your cargo as the demurrage goes up day by day. There's the interesting wrinkle of the last day of demurrage, but I'm not going to go down that rabbit hole either. Liens covering damages comes in a slightly different scenario. So when you exercise the lien, you've got to make a demand. I'm going to skim over this. You're going to make a demand of your consignee anyway. So this requirement is somewhat academic. But in making your demand, you've got to tell the consignee how much you need to be paid to clear out, to raise the lien. You've got to tell the consignee enough so that he can reasonably check the sums due or reach his own conclusion about the sums due. If you don't do all of that, then it'll be an invalid exercise of a lien. That can be quite tricky. In the Lyle shipping case, again in the 19th century, they exercised a lien for 22 days of load port demurrage, when in actual fact there was only 19 due. That didn't invalidate the lien, and Justice Bigham took account of all the circumstances, and he decided that in actual fact the owners just wanted what they were owed, so it was a legitimate, reasonable assessment of what they were owed, rather than maliciously trying to extort more or insisting on what they were not owed. That kind of distinction is rather difficult to make in practice, especially as LMA arbitrators have wisely noted. It should be kept in mind that an apparently unshakable insistence upon the full demand being met is often mere posturing, in which case the cargo owner is not relieved from making a tender. So trying to pick out what's an excessive demand and what isn't is rather difficult. I should just very quickly say you can remedy nowadays an invalid demand, so you can make up for it and reassert it correctly. The only downside that you still suffer is that during the period when you were invalidly exercising your lien because your demand was invalid, late time and demurrage, for example, would not be running because you were the one who was in the wrong, not the consignees. That brings me very quickly to, am I still on the right slide? No, I'm not. I'm being eager with the buttons. That's quickly the problem of the lien for damages. It's easy to see how that's going to cause problems in practice. So while it might be possible to establish a claim for damages has already accrued. So for example, a safe port case is a classic. The owner's ship has gone bump on some unmarked rock on the bottom on the way into the port. And so we can see that there's a cause of action has arisen. But what you can't see is, or can't tell at that point, is how much that claim is going to be. It's very, very difficult to have any idea about what the quantum of that claim would be. So you've got an accrued right damages. You can exercise your lien, but then what do you do? Doesn't seem to be anything on this yet, as far as I'm aware. The editors of void charters suggest that the proper approach in that kind of circumstance would be to draw an analogy with GA, where a very similar problem arises, and say that the consignee has to put up a bond where he effectively accepts personal responsibility for whatever sum is in question for the damages, even though they're not personally liable in theory in the first place, and back that with a guarantee. So just as you'd expect in a GA scenario. Retaining possession. So the essence of the lien is its possessory. These are quite well known now, these scenarios. They haven't changed much for quite some time. You can stop off the discharge port in order to exercise your lien. You don't have to have got to the point of delivery. That recognizes the practical reality that in various jurisdictions, the local authorities and courts are very pro-cargo receiver and will force the discharge of the cargo. In those kind of circumstances, you can stop short of where you're going to get caught by that problem to protect your lien. You're not forced to give it up. You can't stop halfway. You have got to effectively go as far as you can. You can't, as it were, anticipate the exercise of the lien. You've got to go as close as you can get while still protecting your rights to exercise your lien. Effectively, you've got to behave reasonably in all circumstances, is what it boils down to. Once you've exercised your lien, you do not have to keep your cargo on board. You can discharge it into a warehouse, say, at the discharge port, or if it's a hostile jurisdiction to the ship owners, you can take it elsewhere and discharge it there. Again, you've got to behave reasonably in the face of the circumstances that are apparent. The costs of retaining possession, this used to be a thorny issue, which you could give an entire lecture on its own. But Lord Justice Ricks put all that to bed in the Layman Timber. So we're now in a scenario where effectively the costs of exercising the lien will be recoverable by the owner. By hook or by crook, you will manage to find almost certainly a legal hook on which to hang your claim for the costs, whether it's if the relevant charter exists or the contract of carriage has ceased, the rules in the COS about gratuitous bailees being able to recover the costs of caring for someone else's cargo, or if the contract of carriage is still in existence, by way of mitigating the delays caused by the consignees. Now, the crux there is that the consignee, courtesy of Layman Timber, is not allowed to say to you, well, hold on a minute, the only reason there are delays is because you're exercising your lien. Effectively, the lien is invisible to the consignee's obligations. The consignee is still obliged to take delivery as required. And in order to take delivery, he's got to clear the lien. The lien does not, as it were, break the causative link between his obligations and the delay. There is a caveat to that modern scenario, is that unless there's express provision for it, there won't be a lien. The lien will not extend to those costs. So you'll have a claim for them against the cargo owner, which may well be the consignee, but they are not going to be covered by the lien unless the lien expressly says so. Then the sale of the cargo. So if you've got a lien, if you've liened your cargo of wheat, which is the classic example, and you're sitting there and the cargo is beginning to deteriorate, the bugs have got it, a bit of rot set in, you're worried that the value of your lien is plummeting rapidly or is about to. Generally speaking, lien clauses in shipping contracts don't include the right of sale. Again, I'm not sure why not. It would seem to be an obvious addition. However, usually the local courts or competent courts will be able to assist. The English courts have such powers under CPR Part 25. And last year in the Lord Hassam case, there was a good roadmap provided as to how Section 44 also allows a route through to an order for the sale of the preserved cargo, of the liened cargo, sorry. Once the English courts, for example, and I suspect it's true of many other courts, are engaged with that process, they have numerous tools available to make that effective. They can appoint a receiver, they can order the signature to be applied on behalf of parties who are putting up a fight and resisting the sale, and so on. So by hook or by crook, once the court is engaged, the sale should be effective. Once the sale has happened in the usual way, the lien is then transferred into the sale proceeds, and you now have a pot of money against which to proceed. Then last stop on my whistle tour, last station, the loss of the lien. So the obvious one is payment of all the sums due to the owner. If you go right back to the beginning, that quote I read out about what a possessory lien was, paying the sums for which the lien is security is the obvious and only clear way of clearing the lien. The alternative that usually happens in practice is to provide adequate security. I'll come back to that just in a moment. If you surrender possession to anybody, if you lose possession, then the owner will have given up his lien. It depends on possession. And waiver. So that's like Thor mentioned in her freight prepaid bills. In this scenario, just as there, if a consignee is holding a freight prepaid bill and he was unaware that in actual fact the freight hasn't been paid, then the owner will likely be bound by an estoppel. I say likely because the consignee is likely to have relied on the fact that the freight was prepaid, as it was likely part of the sale contract underlying the scenario in the first place. But just as Thor pointed out, if the consignee knows that the freight hasn't been paid, then he can't be stopped. Now, just the last word then is on the provision of adequate security. This has not been tested as far as I know. Quite interested. You don't all have to yell out at once though. What people think needs to be provided as adequate security. Is it simply a guarantee that says, for example, covers whatever may be found to be properly due in respect of demurrage or whatever it is, up to a maximum of whatever? Or, in which case, the owner is left with suit against whoever the party who was personally liable for those sums may be, and then enforces the guarantee having got judgment down that line. Or, like in the GA scenario, is it more akin to requiring the consignee to pay, even though they're not to clear the lien, even though they're not personally responsible for the relevant debt or liability, to put up a bond as well, saying, I accept personal responsibility for, in lieu of having to pay, for whatever sum is found to be legally due, or for whatever the debt, the relevant sum is included, probably also backed by a guarantee. So that's the key. Do you leave the owner with his claim against whoever is personally responsible, but with the guarantee provided by the consignee, or do you also require the consignee to put up a bond undertaking personal liability themselves? So I'll leave it there.
Stephen, you mentioned that there was a Singaporean case which said that you had to register a charge over a sub-lien. And a little birdie. But I put into Google AI assisted, whether that was still good law. And it told me, no, the direct ruling in Diablo, Fortune and Duncan is no longer good law. In the same way, because the Singapore legislature passed a law change in 2018 to specifically exempt ship owners' liens from the registration requirements that the court had applied. So I thought I ought to tell you that.
Thank you.
In case I was otherwise led astray. I have no idea whether it's true, because of course it's AI assisted.
But do you know whether the Singaporean case to begin with was a genuine case? One created by AI.
Thank you. So the effect in Singapore is now, as it was in Hong Kong.
Right.
There is 10 years.
Correct.
That's a very odd concept. The idea that you have to bricks. As you rightly said, I mean, nobody would.
No, they never, no one
Nobody
ever
ever
has.
has done. Nobody
No
ever
one
has
ever
done.
has.
Never has
No.
done. It's weird.
Oh, well, now that means, unfortunately, with those instructions, so.
I'm never going to.
I'm never going to arrive.
Or they're going to go to Richard,
Does anybody, yeah.
who I suspect is even cheaper.
Does anybody else have any question? Or you're all going for the refreshments?
Yes.
Yeah, I think in that case, can I just finally say thank you very much to all three of our speakers. I certainly found it very interesting myself. What amused me, because I've been away from shipping law a little bit for a while, well, I've done some shipping cases as a judge, is that even now, they still don't identify which which charter party they're referring to, which is, you know, one of the problems we used to have when I was doing shipping cases when I was a junior barrister now 30, 40 years ago. It's funny how they never seem to learn. I always remember actually asking a client why it was that even though there was a 1993 NYPE form, they carried on using the 1946 form. He just said, because that's the one we've always used. We're comfortable with it. So maybe that's, you know, maybe identifying the charter parties makes you feel uncomfortable. I don't know.
And they seem to be very comfortable in using it, despite the fact that most of the form is covered in red ink and crossing out.
Right. Anyway, thank you. Can I just finally then invite you all to say thank you to our speakers in the usual way.